We are joined now by attorney Mark Chenoweth. He is the president and chief legal officer of the new Civil Liberties Alliance. Mark, thank you so much for your time. What precisely does the Rahimi ruling mean when it comes to the Second Amendment, and how significant is it?
I'm not sure it's that significant a case. What the court did was reaffirm the test that it used in Bruin, the history and tradition factors, and it just applied those a little bit differently than the Fifth Circuit had, and suggested that perhaps the Fifth Circuit was looking for a little bit too close an analog of historical regulation that would be similar to the federal law at issue here. The court, in an 8-1 decision, said, no, this is pretty analogous to some regulation that existed earlier in American history, and therefore they upheld it.
As you mentioned, this was an 8-1 decision, but 5 separate concurring opinions for 6 justices. What does that reflect about the court's opinion?
Well, I think they all wanted to get a little bit of their view in there about how to do this kind of a test going forward. And so you had Justice Thomas in dissent say that he was really looking for something more specific in the history. You had others like Justice Gorsuch really focus on, well, here's what we're deciding and here's what we're not deciding in this case. Justice Sotomayor wanted to say, well, I didn't like the test in Bruin, but I think that the court has applied it correctly in this instance.
Last week, the U.S. Supreme Court struck down a ban on bump stocks. Your group represented the plaintiff, Michael Cargill. What is your reaction to that ruling? I believe you've said the case goes beyond the issue of guns.
It really does. It wasn't a Second Amendment case, unlike the Rahimi case. Cargill was a statutory interpretation case, and the question really was whether or not the ATF, the regulator, the federal regulator at issue there, could change the definition of machine guns in a way that created new criminal liability for 500,000 bump stock owners. So we were delighted that the court said no. The criminal law writing is the job of Congress. ATF doesn't have the ability to rewrite criminal law via regulation and create this new criminal liability.
These are 2 big gun cases out of the Supreme Court within the span of just 1 week. What do they say about how the court looks at the issue as a whole?
Well, I think what it means with Rahimi is that we haven't really changed that much, that the Bruin test is still the right test. The lower courts maybe need to pay attention to the differences between Rahimi and Bruin itself in terms of how the different federal laws were applied there and draw some lessons from that. To me, the Cargill case is the one that has a much more broadly sweeping impact, because what it says is not just to ATF, but to all federal agencies, you better stay in your statutory lane and not try to write regulations that change the meaning of federal statutes.
Really appreciate your legal insight here. Mark Chenoweth, thank you.
Thank you.